has subpoena powers against President Ramaphosa after he failed to meet the deadline to answer questions relating to the theft at his Phala farm. This after the president asked for another extension. Earlier this month, the Public Protector's Office granted President Ramaphosa an extension after he provided an affidavit asking for a postponement on his submissions. The president claimed that the timeframes provided by the Public Protector's Office were not sufficient to allow him to respond timeously. After threats of a possible subpoena, the presidency says his legal team is in communication with the Public Protector's Office.
The president's legal team is in communication with the office of the PP. So the president will be compliant with his obligation to respond to the PP.
President Ramaphosa had until the 18th of July to respond to the questions. This after his initial request was granted to extend the deadline of the 22nd of June. Instead of providing answers by the deadline, he requested another extension.
Rule 23 sub-rule 3 of the rules provides that where the state institution has failed to submit a reply within the time frames referred to in sub-rule 2 above, the public protector may direct the state institution concerned to submit a substantive reply, which reply must be received no later than 7 days from the date of the directive. The Public Protector South Africa will therefore be invoking its subpoena powers in line with Section 7, subsection 4A of the Public Protector Act.
The African Transformation Movement is the party that originally filed a complaint about President Ramaphosa. Its leader, Vuyo Zungula, was concerned that President Ramaphosa may have violated the executive member's code of ethics by being paid for doing non-governmental work. After the latest development, ATM says is unconvinced that the president will indeed find time to answer the questions.
Given the evasive posture of the president, it cannot be ruled out that the president will instruct his lawyers to challenge the subpoena, and thus the process could be dragged out for weeks on end.
A legal analyst says, for now, it's a game of wait and see.
If he does not, then the public protector will be within her rights to approach the High Court in order to enforce those subpoenas and ultimately, try and bring the president before the public protector through the High Court. Again, that would be something that the president would want to avoid.
Other political parties have also voiced their concerns at the ongoing delays by the president to respond to the public protector's questions. Nhlanhla Khatlhane, SABC News, Johannesburg.
Public Protector Advocate Busisiwe Mkhwebane to hold office. Some lawmakers believe the witnesses must be credible. Others have raised concern about the unfair treatment they've received. The inquiry has discussed in-house matters and how the process has gone thus far.
It's a first for the country. The removal of a head of a Chapter 9 institution is uncharted waters, and the rules of how to handle the inquiry need continuous clarity.
Your contributions and guidance is well appreciated in handling a very important, complex matter for the National Assembly. I hope that you would have been part of starting that important historical journey. But it's very clear that a week later, there might be a few things that we must attend, tighten up, or relook or rethink about.
Suspended public protector Advocate Busisiwe Mkhwebane faces charges of incompetence and misconduct. Some witnesses have come forward willingly or unwillingly to question some of her reports. One witness was accused of drinking whiskey while having medication, while another was accused of lying and dishonesty.
Chairperson, I want to put it on record that during the cross-examination, first of all, of Mr. van Lochrenberg, his medical status was made public for all to see. And secondly, during the cross-examination of Mr. Kekana, there were some really, really horrible insults that were hurled at Mr. Kekana, to the extent that he was called a liar, he was called dishonest, it was absolutely untenable.
The respect should be given to all of us as members of parliament, to the evidence leaders, to the witnesses, to everyone who's involved in this process. So we cannot hurl insult when we can't get our own way. And we want the chairperson to be firm also.
You bring credible witness. I'm not insinuating that I'm not credible, but I had difficulty in both witnesses we have had. The one was part of the so-called rogue element. You could see that there are gray areas. And also on this one, he says, no, I cannot answer you because I still have a court pending case in court.
The expert witness, there was a shortfall. Maybe we expected too much from the expert witness. We expected the expert witness to focus on what I call alternative dispute resolution.
Other members felt Mkhwebane ought to answer some questions immediately rather than defer them to written responses.
I did become concerned that we are raising questions using Rule 5.9 and accumulating a pile of questions for the public protector before she gives evidence. And some of those questions, most of them, all of them, in fact, that I would have asked, could be posed directly to the public protector in response to her evidence.
When the public protector gives evidence in chief through the chair, that there be a set of criteria to decide if chair can either compel her to answer immediately or allow for her to answer or to consult with her counsel first.
Another member felt the suspended public protector and her defense team were subjected to snide remarks by some members.
One honorable member said it seems as if he's going to be playing a delay tactic and is going to stall the process. You know, something in my view that was uncalled for, and it showed that that member is somewhat biased towards the public protector and advocating both. So if there was fairness from your side, you would deal with such, snide remarks that, erode the confidence that the public ought to have that this indeed will be a fair process.
While there are still legal disputes that are being ironed out behind the scenes, the inquiry is due to meet again in the middle of next week. Meanwhile, Mkhwebane will also challenge a suspension by President Cyril Ramaphosa in the High Court in Cape Town on Monday. Lilani Philip, SABC News, Parliament.
Have given the president until Monday to indicate whether or not he will appear before the parliamentary inquiry into her fitness to hold office. Now, in a lawyer that we've seen as the SABC, the lawyers argue that the president has some matters to clarify to the committee, and should the president not be willing to voluntarily avail himself, they say they're exploring further options. And we saw this building up over time. Even last week when, UDM leader, for example, Bantu Olomisa said that he must come, and then the lawyers also indicating, and then we saw the statement by the presidency saying that the president did not make allegations against the public protector. He simply suspended her when it comes to, in line with the Constitution, Section 194, making such provisions for him to do so, for this inquiry to continue. But let's explore this further, and what does it mean then for these proceedings, and how can we see this unfold going forward? We speak now to legal expert and commentator, Advocate Mudadima Manya, who joins us live now. I know, Advocate, we've pulled you out of your birthday celebrations. Thank you so much for joining us. Let's start with this. It was a long time coming, and we saw it being touched on, a number of times last week. Are you surprised that we got to a point where we're now seeing an official letter saying the president must voluntarily appear before this particular committee?
Yes, I'm actually surprised that the threat has been carried out, especially in the manner that it has been done. I'm not sure that the president has got any role to play here, and I've just browsed through the letter, and I don't
terms of the evidence required at the hearing.
Now, let's then look at the fact that, as you say, because he released a statement last week to say he's not going to do this because this was his prerogative as per the Constitution. He didn't make allegations. They're calling on him to voluntarily appear before the commission, or as they say, they'll take necessary steps come Monday if they do not get their way. How do you see this one play out? Could he voluntarily do so, or are we seeing a looming battle in court here?
Look, let's separate the issues. I think the one issue that I think is completely irrelevant to the inquiry is the decision to suspend. It doesn't even belong to Parliament. It's a matter of the President, and as far as we know, it is a matter that is being dealt with in the court of law. But I think separately, and I see from the letter, there seems to be a suggestion that because the President had a matter of the CR7 bank accounts in court, and he deposed to affidavit, he somewhat has some relevance in terms of whether the public protector was incompetent or had or acted in a proper manner. That alone remains a challenge and a problem. But I must indicate, from a procedural point of view, Bondi, and people may not be aware, that if you bring any witness under subpoena to an inquiry of this nature, that witness has no obligation to consult with you. So I'm not even sure how they are going to lead the President, even if he were to agree or to go there under subpoena. The second issue is that the decision to subpoena witnesses is the decision of the chairperson in terms of the directions that have been issued. Now, they still have to go and justify to the chairperson of the Section 194 inquiry why it is necessary to bring the President to give evidence, what would be the relevance of his evidence, and what matters fall within his personal knowledge. It's not just because he didn't make a complaint that he is not required. Anybody who may assist with providing evidence will be required, but I'm not sure whether the evidence of the President in this matter would be relevant at all.
How do you see it then, play out in terms of the inquiry? Could it further delay the proceedings if this goes to court?
Well, I suppose the chairperson would make a determination. If he makes a determination that he's not going to issue a subpoena against the President, we will have to see whether the public protector's lawyers will want to take any legal step. But I don't think any such step would delay the proceedings because the President would not be the only witness. Maybe it may delay at some point in the sense that all the other witnesses may be exhausted and the only evidence that may be required would be this one. This is if there would even be a basis in law to approach the court, because that may as well not be.
All right, let's see then how this one plays out. Thank you so much for your time this evening. I know we stole you from your birthday celebrations. Go then and enjoy them. That is Advocate Modidima Manya, who was looking at this letter that we've now seen that is has given the President until Monday to respond whether or not he is going to voluntarily appear before the Section 194 inquiry into the fitness of the suspended public protector, Advocate Busum Kobane, to hold office, or whether or not this is a matter that we're now going to see the committee dealing with it, because the President even released a statement last week. So it'll be interesting to see how this one plays out.